Good afternoon, everybody. Can you hear me? Now, I suppose you cannot reply. If you want to reply to me at this stage, can you all see the hand up there on the bar? Can you see the hand? If you click on the hand, okay, that's not working. Okay. Yeah. Thank you, guys. Thanks for the response, and thank you for making me notice that you can actually use the conversation, the chat bar as well. My name is Professor Mollema, and I'm a she, not a he, as somebody noted. Thank you for telling me that you can hear me. I will be teaching this lecture. And because I'm one of the lecturers for CRW2601, General Principles of Criminal Law. The other lecturer that's teaching this module is Mr. Ramosa, Mr. Rapalong Ramosa. He will be assisting me today. He will also be teaching, but today he will be assisting me by answering all your queries in this conversation tab. Now, if you can, I see there we go. That is the invitation tab. You can write at the bottom, you can type your whatever you want to ask, and Mr. Ramosa will be answering your queries for you today. I'm just going to get rid of it. Now, I have two people. I have Bontle Maja Motlosi. Bontle, can you please just switch off your camera? And then I have student 6732. He's registered as a guest, 67328962. Could you also please just switch off your camera? It will be appreciated. All right, we just had requests for please switch off your cameras. Now you are muted at the moment. But after the lecture, I will first give a lecture and you may ask questions via this conversation tab while I'm giving the lecture. But after this lecture, we can have a discussion. In other words, I will, as you raise your hand, for example, here is Mr. R. I don't know who he is. He's got a Rebecca. Now, Rebecca, you've already raised your hand for a question, but I'm not going to allow voice questions, vocal questions now. So Rebecca, if you want to lower your hand, you can just click on this hand again and your hand will be lowered. All right. I don't let me just see who's the other. So that goes for Rebecca, for Helena. If you can please just, and Joyce Moloto, please just lower your hands for now, because I will only get, there's another hand there. Joyce, please lower your hand. You lower your hand by clicking on the hand symbol again. All right, Shivika, the same. Maharaj, please lower your hand. All right. Now I have a student here that said I must rather focus on the contents of this. As you know, it's just started, your lecture has just started, and we want this lecture to flow. So if you can just put off your camera, Lekumo Rudolph Tsamake, please put off your camera, it will be appreciated. All right, everybody ready? Lekumo, your camera is still on? All right. Now, guys, you are all registered for CRW2601. That is, like I said before, these general principles of criminal law. We will be discussing in this lecture study units 1 and 2. We will try and stick with only one study unit because they do tend to get quite large later on, you know, that the content of the study units. But because study unit 1, there are quite a few paragraphs that you only need to read. You don't need to have the knowledge for any assignment or for an exam. So that is why we've decided to make this class for study units 1 and 2. Now, if you have a look at the next slide, you will see that that slide basically is the whole study CRW2601 study guide. It basically has introductory topics where it's your theories of punishment. It's read only, as I've said, and then a small part of criminal liability, which is very, very important because the entire rest of the guide is based on what the criminal liability is. The next topic that you will have to focus on is chapter 2, which is your concept of legality. And the principle of legality, and under the principle of legality, we discuss jus acceptans, jus praevim, jus certum, and jus strictum. The next of the study guide is criminal liability, where we finish with the act, definitional elements, and unlawfulness and culpability. The last part of the study guide has to do with attempt, conspiracy, incitement, and participation. But obviously, as you can see, our lecture today is only about chapter 1 and chapter 2. Now, chapter 1, like I said, it consists of introductory topics. So the first one that you have to know, or that you need to take note of, you don't need to study it for exam purposes, is your theories of punishment. So I'm not even going to discuss this with you. I just want you to take a note of this. There is another course where you will discuss the theories of punishment in much more detail. So I need you just to know that there are 3 theories of punishment: the absolute theory, the relative theories, and the combination theories. This is where we start, criminal liability. Now, criminal liability is basically just whether a suspect or an accused is guilty of a certain crime or not. Then he is criminally liable for that crime. To ensure that somebody is liable for a crime, you have to determine the following. You have to determine whether there's an act. Now, an act will be discussed in much more detail in the following in study units 3 and 4, and you have to see whether the act or the conduct complies with the definitional elements of the crime. There are 2 study units on the definitional elements of the crime later on in the study guide. You will also have to see whether the act was unlawful. Now, unlawful basically means, is it contrary to the law? But not only that, is it unlawful as seen against the totality of the rules of law? And sometimes you get certain acts or conduct that complies with the definitional element of a crime, but it is still not unlawful. And that is because there are certain grounds of justification which allows for that act or conduct to be done. For example, something may be seen as assault, and the act complies with the definitional of elements of the crime. But if you have to look at the unlawfulness, it's not assault, it is a policeman arresting a suspect, and he's basically just grabbing hold of the suspect. The last element that it has to comply with is culpability. Now, culpability is the last part of this criminal liability section, right at the back of the study guide. And culpability basically consists of 2 parts. The first part is criminal capacity. Criminal capacity is the ability to appreciate the wrongfulness of the act and to act in accordance with such appreciation. So that person who is suspected of being criminally liable for an act, for crime, he has to have the ability to appreciate the wrongfulness of an act. Now, who doesn't appreciate the wrongfulness of an act? Mentally ill persons do not have the ability to appreciate the wrongfulness of an act, or young children do not have. There are quite a few instances there, well, 3 instances, and that's also listed right at the back of the study guide. And the second part of this, second leg of criminal capacity is to act in accordance with such an act. In other words, with such an appreciation. If you have the ability to appreciate the wrongfulness of an act, and you act thereon, on that appreciation. Oh my gosh. Okay. I'm just having a, I'm going back. Can you see my slides? Thank you, Mr. Kapinga. Thank you so much. I'm seeing you. Okay. So then I can go on as just one lecturer. Thanks, Letabo, Nakita, Rory Sang, and Jalan Jalo. Okay. So the ability to appreciate the wrongfulness of the act and to act in accordance with such appreciation. If I can appreciate the wrongfulness of my act, I can stop there. I can appreciate it, but I don't need to act and actually do that. But now, if I do act on that, then in accordance with such appreciation, you can see that I do have criminal capacity. Now, if one of these 2 legs are missing, then the person does not have criminal capacity. I'm not going to go into this in much more detail. As I say, there are quite a few study units later on in your study guide that's going to explain this to you in detail. And the second part of culpability is whether the person has intention or whether he was negligent. In other words, did he intend to do what he wanted to do, or was they just mere negligence? Let me just quickly see what Mr. Ramosa says. Okay, there we go. Thank you, Mr. Ramosa. So what is very important here, and this is what this study unit 1 makes very clear to you students, is that there's a sequence. You have to ask your questions for criminal liability according to this sequence. You first have to ask whether there was an act. Did the person act? Okay. Was it a voluntary act? Did somebody force this person to act? Or was it a mission where he had to act? All right, so that's the first question. If the answer is yes on that first question, yes, there was an act, then you can move on to the next part and say and ask the question, did the act comply with the definitional elements of the crime? For example, if the act was that somebody, person X killed person Y, the definitional elements of the crime is the causing of the death of another person. So yes, you can say yes, X did cause the death of Y. If that answer is yes, then you can go on to the following, and then you can ask yourself, was the act unlawful? Now, if the person just X killed Y because he was jealous of Y, then there's no question, there's no ground of justification for that. So we can say yes, the act was unlawful. It complied and it was unlawful. Then we move on to the last part, which is the culpability part. In the culpability, we must first ask, did X have criminal capacity? In other words, did he have the ability to appreciate the wrongfulness of the act, and then also to act in accordance with such appreciation? If the answer is yes on both parts, then we move on and say, was it intentional? Now, murder, of course, is only intentional. You don't get negligent murder. So obviously, if it's murder, then it was intention, and we can say yes. We've gone through the sequence, and we can say that X is criminally liable for the crime of murder. Now, that is basically your study unit 1. I'm going to move on to the following slide. Now, the following slide, we start with study unit 2. study unit 2 is the basics. It's the principles of legality. And the principles of legality is basically, that study guide just says to you, it's on from page 12 to page 26. What we're going to look at in this study unit is basically the definition of the principle of legality, or the contents of the principle of legality, where we can find the principle of legality. And it says here, we find it in the Constitution, section 35(3)(L). And we'll tell you just now what it is, what it states there. The next thing we're going to look at is the rules of the principle of legality. Now, as we can see there are 4 rules: use acceptum, use brevium, use certum, or certum, and use strictum. Now, these are Latin names, and you are going to ask me, do we need to know the Latin names? And the answer is yes, you do need to know the Latin names. You need to know what this means in English, or the English version of these Latin names. But sometimes they ask you, please give us the rules of the principle of legality, and they ask for the Latin names. So you need to know these Latin names, and we'll go through it, and I'll try and make you remember in a certain way how you can remember these Latin names. Now, under use acceptum, you see that we discuss 2 further things. We discuss common law crimes and statutory crimes, and we'll tell you just now why we have to concentrate on these 2 types of crimes that we find, because we only have common law crimes and statutory crimes in our law. The last thing of the principle of legality is that we looked at punishment. Now, punishment is not so important in criminal law in the study guide, because there is there was a course on sentencing, but we need you to know that punishment for is also prescribed, the nulla puna sine lege, which means no crime without legal provision or punishment. That is in Constitution section 35(3)(N). And that is basically a summary of this whole study unit 2, based in 1 page. So you can see it in one blink. What is the definition and the contents of the principle of legality? Now, I've already said nullum crimen sine lege. Let me just see what this question is. Okay. And I've already said in that first page that we find it in section 35(3)(L) of the Constitution, the Constitution of the Republic of South Africa, 1996. And that section says, an accused, 1, may not be convicted of a crime, A, unless the type of conduct with which he is charged has been recognized by the law as a crime. Now, already you can see that conduct must be recognized by law as a crime. That already should give you a hint to what rule that is. And that that is the use acceptum, and you can try, and use just stands means law, and acceptum, accepted law. So it has to be recognized by law as a crime. All right. Then it in clear terms. So that's also may not be convicted of crime unless a type of conduct is described in clear terms. Now, already we can look again and just guess that in clear terms, it must be certain, it must not be vaguely described. So that is going to be your use certum. Before the conduct took place. Now, before the conduct took place, it means that you cannot be accused of a crime that there was no crime already on the statute books or as a common law crime. So they cannot create a crime now and charge you with it if you did it last year, if you performed this type of conduct last year. And that just means that you cannot charge somebody retrospectively. Okay, that I'll explain that a little bit later again. And then the last one, D, is you may not be convicted of a crime without it being necessary to interpret the words in the definition broadly. In other words, you cannot, you must interpret the words in the definition strictly. Okay, so that is going to be your use strictum. And there you have, from A to D, you have your 4 rules of the principle of legality. The second part is, if the accused is convicted, that person may not be sentenced unless the sentence also complies with the 4 principles of legality in 1A to 1D. Now, that is the principle of legality. In the previous, when you still had non-venue or venue-based exams, that was a good question to ask, you know, given the principle of legality. But these days, I mean, it's just cut and paste, so I don't think you will be getting it exactly like that. But you need to know where we find the principle of legality in the Constitution and what does it consist of. Okay, now just again to explain the rules, and you will see exactly what I meant when I discussed the previous slide. The courts may not create a crime. That is your use acceptum. In other words, the crime must already be recognized in law. Okay, so courts may not create a crime. Then the next one is use previum. That is, court may only find an accused guilty if the act was recognized as a crime at the time of the commission. And that is, at the time of when the person did the crime, committed the conduct. Okay, there should have already been a crime in the law books. They cannot create a crime after the person already performed the conduct. The third one is crimes must not be formulated vaguely. That's use certum, and just like the previous slide I said, you must be certain, it must be clear. That is why it's called use certum. The fourth one is the court must interpret the definition of the crime narrowly rather than broadly. That's, in other words, the court must interpret the definition of the crime strictly. In other words, that's use strictum. And then all the above rules must also apply to sentencing, which is your nulla puna sine lege principle. Now we're going to discuss each of these rules separately. Now, use acceptum. We said that the courts must not create a crime. The crime must already be recognized in law. And as we know, we have 2 types of crimes. We have common law crimes and we have statutory crimes. The first one, the common law crimes, if there's no provision in common law, there's no crime. And a court has no legislative power to actually create a common law crime. So there we go. Statutory crimes. Now, remember, statutory crimes are in statutes. That is what Parliament or legislature create. Okay, they create crimes, like, for example, the Terrorism Act. So if a Parliament creates a crime, there is a certain way in which they must do it. The Act must first declare, number 1, what type of conduct is a crime. Okay, what is the specific conduct which constitutes a crime? And 2, what the punishment is for that crime. When they create this crime, they have to distinguish between 3 things. They have to distinguish between what a legal norm is, what a criminal norm is, and what a criminal sanction is. And as you will see, the one builds upon the other. A legal norm is basically just merely a provision in an act creating a legal rule, okay, which does not create a crime. For example, as you have in your study guide, it says there, no person is allowed to ride on a train without a ticket. Okay, that's a rule. You can hear it's a plain legal rule. There's no crime yet. Okay. The next one is a criminal norm. Now, that is basically where they take the legal norm and they make clear that this conduct is a crime. This conduct, that certain conduct constitutes a crime. For example, the example that I've given as well is no person may ride on a train without a ticket. And if such person does ride on a train without a ticket, it constitutes a crime. All right, so now I've made it a crime. Now it's a criminal norm, not a legal norm anymore, it's a criminal norm. And a criminal sanction is basically building again on the criminal norm and saying what punishment this court must give or impose after conviction of this specific crime. Again, in our example that we've given, we've said no person may ride on a train. And if such a person does ride on a train without a ticket, that constitutes a crime, which is punishable by a 500 Rand fine or a week in prison or something like that. Okay, so now I've actually put a punishment on that criminal norm, and it's become a criminal sanction. And that is how you create a crime, a statutory crime. Now, in the following case, the Director of Public Prosecutions, the Prince case, Western Cape versus Prince, they said it was stated that no crime is created in the absence of a penalty clause in a particular legislation. If that happens, the imposition of punishment is left to the discretion of the court. Now, if you have to go, I think you have to go and read the Prince case. It's a very interesting case. It's basically to do with the Sexual Offences Act, and the Sexual Offences Act did not have prescribe a certain punishment for a crime in that act, which Prince again took up in court and said that there is no penalty clause in that particular legislation, so the court cannot prescribe a punishment to him, so he must be free to go. And then it says no, it's not the truth. The imposition of the punishment is then left to the discretion of the court. Now, this case is discussed quite well in your study guide. I think in the study, in your tutorial letter 102, there's also a discussion. Just go and have a look there as well. So I'm not going to say anything more. If you have any questions about this particular case, please feel free to ask. Now, jus praevium, I'm just watching the time here. Jus praevium is that you cannot create a crime with retrospective effect. It's not legal. And that is, of course, in section 35(3)(l) of the Constitution. Then the jus saptem, very easy. Crimes must be formulated clearly and not vaguely. The last one that we have to do here is the jus strictum. Now, this is where the provisions creating crimes must be interpreted strictly. Where any doubt exists concerning the interpretation, the accused must be given the benefit of the doubt. Now, that already is in the Constitution. And then the court is not authorized to extend the field of crime, the application of the field of the crime. Now, what that means is the court cannot create a crime, but the court is not allowed to extend the application of that crimes field as well. And here we've given you an example, the Masia case. The Masia case is one of your prescribed cases, so you must go and read it. Remember that for your prescribed cases, you need to know your case facts. In other words, what the case is about. But you also need to know the legal question. In other words, what the question was in this particular case, what the problem was that the court had to resolve. And then, of course, what the decision was in the court as well, the decision of the court. So in this Masia case, it involved a person, a male, who penetrated an 8-year-old anally, and when the case was went to court, the definition, he was charged with rape, but the definition of rape did not include anal penetration. It was basically still the old pre-2007 definition, which said that it's the unlawful and intentional penetration of a male by of a female by a male, and via the respective genital organs, but it was only the vagina, in other words, of the female, penetration of the vagina, not the anus. So obviously, when this case came to court, the prosecution said that this person, Masia, should rather be charged with indecent assault because, and that is another crime that we had in those days, pre-2007, the Sexual Offences Act. But the magistrate did not agree, and said he will extend, he said that the definition of rape is unconstitutional and needs to be extended to also include penetration of the anus. So although Masia was not charged with rape, and remember that you cannot charge somebody retrospectively, okay? So it was changed. The court actually did extend the field of application of the crime. So they extended the definition of rape. I don't know whether there's probably going to be quite a lot of questions about that if you do not understand that, but you know, it is important to ask. There were definitely reasons why the magistrate did extend that application or the definition of a rape. The court case came just before the introduction of the 2007 Sexual Offences Amendment Act. So obviously the magistrate knew that and thought that, you know, he could already extend the definition of rape to all the cases after Masia until the act is introduced, so that all the conduct where there's unlawful and intentional penetration of a female via the anus will be covered under the definition of rape. Okay, but you have to remember, use strictum. That means that you have to interpret crimes strictly. The last one that we have, let me just quickly go on, is your principle of legality and punishment. Now, again, it's basically taking the rules of legality and applying them to punishment. Nulla puna sine lege, no penalty without statutory provision or legal rules. So if you look at jus acceptum, the court can only impose punishment prescribed by statutory or common law. Jus previum, if a punishment is increased, it may not be imposed to the detriment of the accused. Punishment in jus certum, the punishment ought to be defined very clearly, okay? And the jus strictum punishment, an ambiguous punishment must be interpreted strictly. So clearly and strictly. And there's a summary. I'm going to the whole principles. Now, this is the effect of the rules embodied in the principle of legality. Everything summarized on one page. So there you can clearly see what we have done here with the 4 rules of legality. Okay, now the last thing, remember, and you'll see this in every lecture, that these notes are only supplementary. Remember that your primary source for studying is your study guide and your reader, and your textbook. So those are still your prime sources from which to study. And then there we go. Thank you for attending this class. Let me just quickly go out here. And share. All right. Now, I am going to ask, I don't know how many questions we have. I see Mr. Sile. Sibanda has his hand up already. Let me see how many still. Oh, there we go. We have many. I'm going to ask Mr. Ramosa to unmute himself as well so that he can help answer the questions. But here we go. Let's see whether this works. I'm going to unmute you. Yes, you can ask the first question. Unmute yourself. Okay. Let's go to the next one who wants to ask. That's Matapelo. Matapelo, I'm going to unmute you. Matapelo? There we go.
Hi, ma'am. Can you?
Yes, I can hear you. Thank you so much.
Okay, ma'am. I just need to go back a bit. In the Masia case, ma'am.
Yes.
The court used its own discretion to extend the definition of rape, right? Hello?
You must just, I lost you there a little bit.
No.
Matapelo, you've gone.
Can you hear me, ma'am?
Now you're back again. Yes.
Okay. In the Masia case,
yes,
the court used its own discretion to extend the definition of rape, right?
Yes.
So my question is, can a magistrate use his own discretion in constitutional matters, or did it have to go to a constitutional court because there was now a constitutional matter because the court found out that the definition was unconstitutional, ma'am?
Yes, you are right. It went all the way to the Constitutional Court. If you have a look in your study guide on page 16, 17, you will see that, and I'm just reading from the study guide as well, where the court stated that in a constitutional democracy such as ours, the legislature, okay, the parliament in other words, and not the courts, has the major responsibility for law reform. Okay, so yes, it's a good question. It did, because what the magistrate did was not correct. You understand that, eh? That, I mean, they expanded the field of that crime. The reasons given were quite, it was good reasons, like I said, but you cannot do that. There are it's only legislature who can extend or change or create a crime. So you cannot do that.
Okay, right. Thank you.
Now, Rapalang, can you unmute yourself there? Marega, can you take off your camera, please? Let me just quickly see, where is Rapalang? Rapalang? Oh gosh. Ah, there we go. Rapalang? Rapalang, can you just unmute yourself there?
Hello, can everyone hear me?
Yes, we can. Thank you so much, Mr. Ramosa. I'm asking you to please, I'm asking you to please to contribute here on this, because I know that you are an expert on the Masia case. Mr. Ramosa wrote an excellent article on the Masia case. So if you can just contribute here, I would be very glad.
Thank you, Professor Molema. In the Masia case, students, a 44-year-old man anally penetrated a 9-year-old girl and was charged with rape. Now, at the time, the definition of rape was defined as the unlawful and intentional sexual intercourse of the male penis into the woman's vagina without consent. So as you can tell from that definition, it was very specific about how rape can be performed, only by the use of a male penis into the vagina of a female. That was the only way that rape could be done. But in this instance, the facts were that the accused had anally penetrated the female. So the magistrate court decided that it will change the definition and expand it to include anal penetration within. And then afterwards, it then convicted Mr. Masia of the new definition, despite the fact that at that time, when Mr. Masia committed the offense, the definition did not include anal penetration. So as you can tell, the jus pravium rule was actually violated, because you cannot be convicted of a crime, and Section 35(3)(L) of the Constitution makes it clear. You cannot be convicted of a crime if the act itself that you committed was not a crime at the time that it was committed, or if it was a crime, it was not the severest crime that existed at the time. So in other words, at the time when Masia committed the act of penetrating the female, it was indecent assault. It was not rape. So the courts did not have a right to do that. So the matter went all the way up to the High Court and then to the Con Court. Now, interestingly, all you need to know is the Con Court matter. It is discussed fully on pages 20 to 23 of your study guide, and you can also see it in your case law reader. In short, now, the Con Court, interestingly, had two judgments. There was a majority judgment. The majority judgment by Justice Ngabinde held that the definition be extended to include anal penetration, but decided that the courts could not extend it beyond the specific facts, which meant that they could not extend it beyond the fact that a male had penetrated a female. In other words, they couldn't include homosexual penetration without consent, because the facts limited the court to a male penetrated a female. That's what the majority decided. But the minority decided that it doesn't make sense to limit it only to a male and a female. There are considerations that require us to even extend it to include male to male without consent. But that was a minority judgment by Justice, the then Chief Justice Pius Langer. So all you need to know now is what's interesting is that the two rules of legality applied, jus pravium and jus strictum. Jus pravium applied because the court decided that it would be unfair for the accused now to be convicted if at the time when he committed the anal penetration, it was not defined as rape. So the accused was not convicted of the expanded definition of rape because at the time it was not rape. But the court held that courts can extend or expand the definitions of crimes if it will give effect to the values of the Constitution. And that was the basis on which they expanded the definition of the crime of rape. So whilst they complied with the jus pravium rule, they seemingly did not comply with the jus strictum rule. Please make sure that you understand how those two rules in particular applied in that instance. Professor Mollema?
Mr. Ramosa, thank you so much. That was excellent. Matapelo, is your question answered?
Yes, ma'am. Thank you.
Thank you, my dear. The next one that we will go to is Is it Totlwana? Totlwana, please, I've unmuted you. Please ask your question. Is it Totlwana Khatlaki? All right. While he's struggling to get there, let's go to Lebogang. Lebogang, I'm muting you. Lebogang, please ask your question. Okay. Nobody there. All right. Mandisi, are you there? Please unmute yourself and ask your question. Guys, remember as well that if you cannot ask your question here, I see Mandisi is there. If you cannot ask your question,
Prof.
Can you hear me, Mandisi?
I can hear you very fine, Prof. Thank you very
that's
much to you,
Please
Mr.
ask your
Ramosa.
question, Mr. Mandisi.
Yes. Prof, I wanted to ask, when obviously we've got those 4 principles of legality and everything, US previum, acceptum, clear, all those. But I see, as Mr. Ramosa was just explaining now, when does our courts then decide that now this case now will go away or will do away with that, and then we'll do our own thing? Because it seems like our courts are freestyling now. Because if we are learning that there are these and then we are sticking to these, then I find it strange that our courts are freestyling, especially in the Masia case. I don't agree with what he did, though.
Okay, now, Mr. Mandisi, there's not actually quite a lot of these cases where courts went and they created their own crimes. In the Masia case, that's why even this case, Masia case, it's quite an old case. So, we're trying to make use of examples in the study guide where we can explain these principles of legality to you. But now, we cannot now, there is a whole module dedicated to jurisprudence and courts decisions. So for us now, we just need to concentrate on the principles of legality, which is part of the general principles of criminal law. So, like I said, we could have probably make use of more recent cases, but there aren't so many cases where the courts actually overstep their jurisdictions or their boundaries. But it's a good question. Thank you so much.
Professor Mulma?
Yes.
Can I come in also
yes,
there?
Please answer.
Yeah, just to say that what's important is that the courts justify the extent to which they want to comply with those rules. Now, what's interesting is that all you need to know as students is the meaning of each of those rules and how to identify whether they've been complied with or not. That's what I would like to encourage you to focus on: the meaning of each rule and how it's been complied with, and whether it's been complied with or not. And you need to be able to explain or justify why it has been complied with or why it has not been complied with. That's a very important thing that you need to know. Hope that answers your question.
Thank you, Mr. Ramosa. Let's go to the next one. Okay, they're still not there. Tebano Masenya. Just unmute yourself, Tebano.
All right, I did. Can
There
everyone
we
hear me?
go. Good afternoon.
Good afternoon, Prof. I wanted to ask, with what we discussed, with culpability, when we mentioned the second component, right? The
Yes.
act has to be intentional or negligent.
Yes.
Since we have that sequence of requirement that tells us, like, that makes just everything easy for us to tell us that we have to see if the act was voluntary, and if no, then the accused is not liable, and if yes, then we have to go forth with getting if the act complied with the elements. So my question is negligence voluntary? Because if someone is acting negligent, it's almost as if.
Okay, now first, when you get to the chapter on intention or negligence, you don't you will see exactly what negligence means, but there's no question of voluntariness there. The voluntariness comes with the act. Okay, so if you go back right at the beginning when you discuss the act, okay, the first question is was there an act or an omission, and is the was the act or omission, was it voluntary? If it was not voluntary, then the whole question, there's no criminal liability. It just ends there. The whole question for the sequence and so on, you don't need to follow it anymore. So there will be no voluntariness. You have to go through this whole and no criminal liability. In other words, the person will not be guilty of whatever crime they've accused him of. Do you understand that?
Yes.
You're not. All right. Shall we go back?
I understand it, but then I'm just trying to figure, like, put it into practicality. If someone did something and it was not the intention to do that, but
okay, now remember, now listen to what you said now. You said somebody did something voluntary, but it was not the intention to do it. So you're not following that sequence. All right. You're jumping from act to intention, which is right at the last question you must ask yourself. Do you understand?
Alrighty.
So if you want to determine criminal liability, you have to follow that whole sequence, and you have to ask, you have to go through it to an act, okay, and say, yes, there was an act. Okay, what was the act? Let's make up an act. Let's say murder again. All right. Did it comply with the definitional elements of murder? Yes, it did comply. The person is dead. The other person is dead. Okay. Then the next one is unlawfulness. Was the act unlawful? In other words, did the person have any reason why he did this? Was there a reason? Was there a ground of justification? Now, this person may have been attacked by somebody. All right. So he was defending himself. Okay. So he can then, if that person was defending himself and that other person died, okay, then he has the ground of justification of private defense. So then it ends there. He's got he's not criminally liable. Understand? But if he doesn't have a ground of justification, then we move on to the following one, which is the last one, which is culpability. Then we ask, okay, does the person have criminal capacity? It's those two legs that we were talking about. You can still remember those two legs. If a person is not mentally ill and he did act on his, in other words, he did appreciate his let me just quickly say, he did, there's, oh, sorry, man. I just want to go, sorry, I'm just recovering from a bit of flu. He did have the ability to appreciate the wrongfulness of his act. In other words, he knows what he's doing is right or wrong, and he did have the ability to act in accordance with such an appreciation. If we can say that this is true, he did know what he was doing was wrong, and he did act, and he still went along and acted. Then we can only ask, was this act intentional or was it negligent? Okay. And this is only where if he did not intend to do it, like you say, we can only answer it yeah and say that perhaps, it was negligent because there's no intention present in that. So it must be the negligent causing of a death, which is culpable homicide.
Thank you.
Sorry, man. If you still need to ask questions, please, guys, this is quite hectic, with all the people here asking at the same time. Please email us and we will answer your question. All right. Right. Letuma Bosaleti, I'm unmuting you.
Yes, ma'am. Good afternoon.
You wanted to ask a question?
Yes, please. I just need is bit of a clarity on what you just said. pertaining to when we talk about issue acceptance, where
Yes.
on one of your slides, where you talked about the director of public prosecution, Western Cape versus Prince. There,
Yes.
he said, no crime created in the absence of penalty clause in
Yes.
particular legislation. So,
Yes.
and then it further goes say imposition of punishment is left to the discretion of the court. But
Yes.
now that's where I'm getting lost to, because we know that there won't be any criminal sanction. There must be a criminal sanction first before on a particular crime. That was the first thing. And also the second part, I just needed to, is the first question. Second part is that I just need you to, on the very same slide, to clarify on common law crimes, where you said no provision in common law. I just didn't get to right there. So those are
All
the two
right.
questions.
Let's do the last one. Remember what I'm saying, if no provision in common law, is that you know what common law is. It's the law that's been transferred throughout the ages. So there's nothing it's not created by legislature. I can't go and point down and say this is the statute, this is the article, this is the section. All right. I think that is that is the answer. But if the other thing is, if there's no crime in common law, there's no crime. They can't create a crime, a common law crime. Especially courts cannot create. Well, no, they can't create a common law crime. It's as easy as that. The Prince case. Now,
Prof.
yes.
Mollema, can I come in there? I see your voice is croaking a bit.
Yes, please. I'm just swallowing some water here as well.
Yeah, let me give you a chance, a bit of a break there. Thank you for the question there. In the Prince case, what happened is that the accused was charged under the Sexual Offences Act. Now, the Sexual Offences Act has got an anomaly. It actually has got a series of offences, but it does not state the punishments in the actual act. Now, what the court then decided, on behalf of the accused, it was argued that no crime was created because there was no punishment. So the lawyer on behalf of the accused tried to justify and say that there's actually no existence of a crime because there's no express articulation of a punishment within the act itself. But remember one thing. I want you guys to remember one thing. The 4 rules of legality, they apply both to the creation and the application of the crime, and they apply to the creation and application of a punishment. So when it applies to the crime, it's the nullum crimen sine lege, which is no crime without a law. When it applies to the punishment, it's nulla puna sine lege, no punishment without the law. So what the SCA then did is that it separated the 2 inquiries and asked itself, do we have a crime when we read the actual statute and the provision, and held that the statute does create a crime. So the nulla crimen rule was satisfied. Then it turned and said, do we have a punishment here? In the absence of an express punishment in the legislation, as long as the crime exists and was lawfully created legislatively, then what the court can do is that it can go to the Criminal Procedures Act. There's a section in the Criminal Procedure Act that creates a series of punishments that the courts can use to apply in circumstances where the specific legislation does not specify a particular punishment. And then the other thing that the court also stressed is that the discretion to apply punishment has always existed within the judiciary in terms of our common law. So in other words, the courts, as long as a crime exists and has been lawfully created, the discretion to apply punishment exists from the common law. The source of punishment is common law. So in other words, the courts could use the common law, or they could rely on a particular statute which applies for punishments for certain scheduled offenses. So Section 276 of the Criminal Procedure Act, for certain scheduled offenses, creates a general provision for punishments that the courts can apply. So in other words, that's how the Nalam Puna Sine Lege principle was satisfied in the case of Prince. Professor Malma?
Thank you so much, Mr. Ramosa. I'm going to go on with the other questions. Lorna, can you switch off your camera, my dear? Okay, if you have, please just lower your hand. You know how to lower your hand if your question has been answered. In other words, just click on the hand symbol again and it will go down. Thank you so much. Okay, now I'm going to, oh, see, I can't, Mr. Ramosa, you must help me look here who asked. Lorna has asked the question. Let's go to Shepherd. Sorry if I did not. Sorry if I skip you. I'm just answering the questions as the hands are showing. Shepherd, I've unmuted you.
Prof,
yes.
I will help you from my side to identify who's next. So you can ask me afterwards. Ask me.
Thank you, Mr. Ramosa. Shepherd?
Yeah, thank you. Mr. Ramosa has just answered part of the question that I had, but the second question I had was, is there an instance that can be cited where a person was convicted, but the courts failed to impose a sentence because they could not comply to the set of rules where there is no punishment without legal provision? Thank you.
Mr. Ramosa?
Should I answer the question?
My voice is really failing me. Hopefully it will be better next week.
Okay. No, it's fine, Prof. Shepherd, that has never happened. It has never happened in the situation whereby a legislature has created a crime, or a crime already exists in terms of common law, and the courts have been unable to impose a punishment. It has never happened. It has always been within the inherent powers of the court as derived from common law to be able to impose a punishment. Trust that helps. Prof. Molema, the next person is Makoma. Sorry, there's a, sorry, Petile. Petile, can I have your question, please?
Petile, you have been unmuted.
Can you hear me? Can
yes,
you hear me?
Petile.
Makoma. Okay.
Oh, Makoma.
I'm here.
Makoma, I can hear you.
Oh.
Okay, let Petile start first, and then Makoma, you'll come afterwards. Okay.
Thank you. Okay. I'm trying to understand the whole thing. I'm going to take you guys back to the Masia case a bit. I understand he was charged for a lesser crime, which is indecent assault, right? Rather than rape, because at the time, rape was not recognized. Anal penetration was not recognized as a crime at the time, right? So,
okay, let me come in there. Petile, he was charged with rape.
With rape,
actually.
it was.
Yeah, he was charged with rape. Yeah.
Okay, but then that was discovered to be wrong, because at the time, if that's what I understood, did they say at the time rape was only up to when it's a penetration to the vagina, and here this guy had penetrated the 8-year-old girl in the anus, right? But
All right, let me allow you to finish.
I'm a bit
So,
confused.
okay, let me allow you to finish. Just let me know when you're finished asking the question. Then I can come in.
Okay. My question is now, if he already knew that what he was doing, like he's quite aware that what he was doing, penetrating a young girl in the anus, is wrong, and yet he's still being charged for, when they revised the sentencing, he was charged for as assault, if that's what I understood. I'm really confused. So I'm not sure whether he was charged for what you call, oh God,
Okay.
indecent assault, sexual assault, and rather than rape.
Okay,
which one was he really charged for?
Okay, let me help you here.
Yeah.
Remember that it is within the discretion of the prosecution to present a charge.
Yeah.
So the prosecution decided to present the charge of rape against this particular person, despite the fact that factually Masia had anally penetrated a 9-year-old. So the prosecution presented the charge of rape, and at the time, the charge or the definition of rape only specifies penile penetration to the woman's vagina. So then the court, being the magistrate, decided to change the definition to include anal penetration and then convict Masia. Under the new definition.
Okay, thank you so much. Thank you.
All right. Makoma? Makoma? Can you ask the question?
Makoma, you're unmuted.
Yes, can you hear me?
Yes, I can.
I say my question is, where do customary law fits in, where the crime is not defined, and also where there is no sentencing?
Okay. All right. That's a very interesting question.
That is a wonderful question. Good luck, Mr. Bosa.
Thank you very much. I think, and I want to just preface this to say that it's an interesting question because ultimately we have to decolonize our criminal law, so to speak, or to present African knowledge of ideas or African concepts and ideas to certain things. So we are in this journey to develop even customary law of crimes in that respect. So for now, unfortunately, our common law is the one that governs our criminal law. Otherwise, the customary process is usually handled at the level of traditional chiefs at this current moment. And so that's why I say that we are still in this journey to decolonize and this journey to Africanize our criminal law, meaning to give recognition to indigenous knowledge systems and their concepts within what rape, for example, means and what theft, for example, means. I hope that answers your question.
Yeah. I think I just want just a further question. Where we are now, if I don't have an example of a crime under customary law, but my question will be, is a hypothetical one, to say, if I have under customary practices, there's a crime under that definition conducted, can I go to a normal court, to a normal police station and open a case that can be prosecuted under customary law?
I think what's interesting is that you will find, Makoma, that many offenses against the person or against property or against family relations, many of them are covered already in the common law, one way or another. I don't think you can say necessarily that you want the court now to divorce itself from excising what the law says in the common law, because, as I said, rape. A classic example, for example, look at ukutwala. Ukutwala is actually abduction. If you think about it, it's the common law crime of abduction. But in customary law, it's known as ukutwala, and the manner in which customary law addresses it is different from what the common law would address it. But the concept of it is that ukutwala, just like common law abduction, you are taking the minor outside of the control of the parents or guardians. So it's a violation against parental authority. Yeah.
Okay. Okay then. Thank you.
Tandeka, can I just ask if if we can just take the last three questions that I'm seeing right now, so that we can end the lecture. Please feel free to ask questions in the My UNISA discussion forum. If I have not answered your question or we have not answered your question, we will engage you in the discussion forum on My UNISA. So can I ask for now, can I see three hands? I see Tandeka, I see WDW7828. I see Tsogofatso, I see David. Can I ask that we stop at David? And then the next line of question or comments can be addressed at the discussion forum. This is for the purpose of just saving time. Tandeka, can you?
Yes, thank you. I can unmute now. So for me, it's a general question. It's not necessarily for the lesson we've just had. I think the lesson was very, very informative, and I wanted to find out if it's possible to get maybe classes 2-3 weeks in advance. So if we could get like a calendar, if possible, so we can try to plot them on our other work calendars. It's just a general question. Thanks.
Tandega, sorry, we do have a calendar or set out, but as we said, we don't know sometimes what will happen in the future, so we don't know. We can upload that for you, but dates may change. For example, if somebody gets ill, one of us gets ill, Mr. Ramosa, I definitely need Mr. Ramosa in his lectures, as I know, and Mr. Ramosa will also need somebody else to help him. So, but I will upload the calendar for you. All right.
Okay, thank you so much. I'll also look out for the email, so I'll know if dates are changing or anything like that. But it will help, especially because of work.
Yes, of course, I understand that completely. Please just remember, Tandi, that if you have any further questions, just to email any of your lecturers and we will help you immediately. All right.
Thank you so much. I think the lesson was very, very great. Thank you.
Thank you so much, Tandega.
WDW, can you please identify yourself once you are unmuted?
You are unmuted.
WDW7828. Okay, Tsogofatso. After WDW, it is Sofatso.
Thank you.
Hello.
Hello. Hello, hi,
Okay.
can you hear me?
Clearly. Continue.
Yes, I'm not sure. I'm not sure if what I'm going to ask is related to what we're talking about, right? But with regarding to capability, they say that the first of these requirements that is that it means that a person must be able to acknowledge what they've done, right? So I want to know that does the same thing applies when someone is a victim of a certain conduct or certain thing that has happened? Let's say a child or an insane person. Let's say that person is a victim of something. Are they allowed, or are they going to be taken seriously if they were to report what has happened to them at a young age or at that insane moment?
Okay, let me make sure that I understood your question properly, or at least your statement of facts. Are you saying that the victim in this instance is insane?
Yes, or it's a baby, or it's someone that is still young, someone that is maybe under the age of 10 or under the age of 12.
Okay, no, I understand. So, somebody somebody who's in either somebody who's either insane or is a minor
Yes.
has been violated. Is
Yes.
that the set of facts?
Yes,
Now,
let's
okay,
say it's just it's a person that is insane in a baby, or okay, let's say it's a minor, with a
yes.
person that is old at that particular time. Are they going to be taken seriously if they were to take the matter to the police station at that young age, or because they're young and they are unable to acknowledge certain things at that particular point, their facts are not going to be taken seriously, or there has to be someone, maybe someone that is old as a witness to be able to do that on their behalf?
No, thank you for the question. They will be taken seriously. In fact, crimes have no prescription. In other words, there's no time frame as far as when a crime can be brought. And a classic example of that is that there was a tennis coach. I think there was a case of a tennis coach who had who was old, had sexually violated some of her mentees, some of his mentees at the time when they were very young under his tutelage. That case was brought, I think, after 20, almost 20 years, and he was still convicted of crimes.
Oh, okay.
Yeah. So a crime is a crime. It does not expire. If the matter is reported to the police will take it seriously, especially given the vulnerability of the victim.
Okay. Okay, thank you.
Okay. WDW, are you still available? WDW? Okay, and then David, guest. David? David, can you unmute yourself? I see your hand. Okay. Okay, David's not there. Look, okay, I'm taking the final two questions that I'm seeing right now. I'm seeing two hands, Odwa and Joanne. You will be the last people to ask questions. Please, can we respect everybody's time, colleagues? Or please, so that we can at least allow everyone to continue with their lives and their business. So can I ask Odwa Gogo to okay?
So I just wanted to actually latch on to the question that was asked by the previous student. I just want to ask, in that situation, as much as the people that are accused of the crimes have to be assessed regarding their criminal capacity, I would also think, or I'm assuming, that victims would be also assessed. For example, in that point where the person is maybe of a younger age or they're probably maybe psychotic, then what it is that you would then ask is regarding their trialability. They're the victim, but are they able to actually be within a court to be trialed regarding what it is that they say that has been done unto them?
All right, good question, Odwa. Here's the point. At the time when they were violated, they were either too young, if it's a minor, or they did not have the capacity to understand what was happening to them. And bear in mind, in any of those situations, assuming that we're talking about a sexual offense, there was no consent. So there could not be consent that could be recognized by law in any event. So definitely what would happen is that reports would have to be produced by psychologists and social workers. There will be obviously a rape kit that will serve as evidence. And then the case should be easy to prove and establish in court without any need for that minor or that insane person to give testimony.
Okay, I understand, sir. Thank you.
Mr.
All
Ramosa,
right.
can I just chip in there quickly?
Yes,
Odwa,
yes.
Yeah, thank you. Odwa, just remember that this is study unit 8, where mentally ill persons and children have diminished responsibility. So I think as soon as you get to that study unit, you will understand it much better. So, and that will obviously form one of the lectures that we will have in the future. So don't worry, we'll get to that question again. But remember, for criminal law, this is substantive criminal law, and we do not actually concentrate, except for the onus of proof in this matter, on the procedural aspects as such. All right.
Okay, thank you, Prof. Thanks, you.
Odwa. Best of luck with your studies.
Thank you, Prof.
Oh, all right, thank you, Odwa. The last person is Joanne. We will take Joanne and then we will end the lecture afterwards. Joanne? Can you unmute yourself, Joanne?
Joanne, you have been unmuted. Joanne?
Okay, Prof. Molema, you can conclude the process.
Mr. Ramosa, first of all, I want to thank you. I have a wonderful colleague in you, and I appreciate everything you do for the subject and for our students. Thank you, students, for coming to this lecture and staying so long as well over your time. I will upload the notes as well as the link to the recording on my UNISA. But remember that if you go back to this week 1 online lecture, the discussions, under your discussions, there will be the video as well. But so you can access the video either through the My UNISA or through your discussions in this forum. Thank you so much, guys, and I wish you the best of luck for the rest of the week. Mr. Ramosa, you want to say your last few words?
I just want to thank you for being so engaging, and I look forward to other lectures in the coming weeks whereby you'll engage with the contents. Thank you very much.
Bye, guys.